Hi there, and welcome to a brief internal overview of the EU and UK Russia sanctions. Obviously, particularly difficult times for everyone in Ukraine, but also conscious that a lot of clients have a lot of interest and concern about what they are allowed to do, what they're required to do, what they're not allowed to do. So we've produced a high-level overview, and I know that the team in Brussels are producing a bit of a deeper dive in some of the EU measures, and we'll do the same on the UK. But I thought also, Jochen and I both thought it'd be helpful to have a brief canter through some of those sanctions. So just a brief introduction of who we are. My name is Andy Hood. I am a partner in the international trade team and the regulatory team here in London. And Jochen is a partner in the international trade team in Brussels with a particular expertise in sanctions and export controls along other trade matters. So that's who we are. A brief overview of what we want to cover, set out some of the measures and give you a flavour of what they're like and how they might impact clients. I don't want to go, this isn't a lecture or a seminar in that sense. We do want to give you a bit of a flavour of what they might be like so that you're able to assess whether clients may be interested, or at least be able to have started a conversation with them before getting specific advice. Then of course, focusing on the impact on clients, how we can help, and then finally, at the behest of quite properly our compliance team, just a bit of a heads up on what we should be doing to make sure we're on the right side of the law ourselves and where to go for help if need be. So that's very briefly where we are, what we want to cover. Just in terms of the overview, I'll pick up the bottom point and then perhaps hand over to Jochen, really to make the point in that bottom box that they are the impact, and when one falls under the jurisdiction of UK and EU sanctions, is pretty broad, perhaps not as broad as some of the US measures that we all hear about in the press, but certainly broader than most or many other regulatory measures we're used to hearing about. So they apply, for example, to all UK or EU citizens, wherever they're located in the world. And clearly there are different regimes for the UK and the EU, but they apply to our respective citizens, wherever they're based, to any business conducted in whole or in part in the UK or the EU, and to all UK or EU incorporated entities. So potentially quite a broad impact on clients who will have at least some potential interest to know whether they're affected or not. And maybe they're not caught, but at least the potential scope for them being caught is quite broad, and just wanted to flag that. Jochen, is it worthwhile talking then through the sort of three types of sanctions that are out there before we do a bit of a deeper dive?
Yeah, so good morning, everybody. Thanks for joining this webinar. You've seen in the last week there was a lot of media press coverage. Those ones of you that might have followed it more closely have received multiple client alerts already from other firms and questions from clients, etc. So, and you saw maybe or not that the measures last week were basically done in 3 tranches. Last Wednesday was the first set of tranche in the EU. Last Friday, the second set, which was actually the core of the measures, the really hard measures. And then on Monday, yesterday, there were an additional 2 rounds, one in the morning, one in the afternoon, of again additional measures. So it creates a lot of confusion, but it really boils down to 3 legal bases and 3 types of measures. And maybe that should help you a little bit to understand the scope and to package them. So you on the one hand have denied party listings, and we go through all of those in more detail. And they're basically set out in the EU in this regulation 269, and in UK in the Sanction and Monetary Laundering Act. And then you have the substantive sanctions. By substantive, we mean sanctions that go beyond the listing of individual parties. So that prohibits certain types of goods exports, certain types of investments, etc. Those are in this legal basis package. And then you have this region-specific sanctions that are basically targeted. Initially, that was for Crimea and Sevastopol in 2014. And those sanctions have been basically now copy-pasted and also applying to the new 2 regions, Donetsk and Luhansk. So that is maybe important for you to understand, because it can become very confusing. The way these sanctions are basically structured is you have building blocks, and depending on, or the commission or the authorities have building blocks, and depending on what they want to achieve, they open the drawer and take out one or the other building block in order to build their sanctions. And the next slide, please.
There you go.
Are we on the next slide? I still see the same, but okay, perfect. If everybody else is. So if you go to the first set of sanctions, the denied party lists, there is always this buzzword out there, denied parties. But what does it really mean? What does it mean for us? What does it mean for the parties that are listed? And these denied party listings usually have three elements to them. The third one is usually there is a travel ban linked to it, especially if this person is not a EU resident. The other two are though the more severe ones in terms of business opportunities. So the first one would be that funds of denied parties that are in the EU or in the UK will usually be frozen. That means the government gives an instructions to bank to freeze those funds. There will be certain exemptions, for instance, to pay rent, to pay legal fees, etc. But for most other points, it will be frozen. And the other severe measure is that these parties are not allowed to be made business with. That means this is a prohibition that is directed to all of us. Let's say you as a EU citizen, you as a UK citizen, we as EU citizens, we as UK citizens are not allowed to make available funds or economic resources to denied parties. And this is specifically vague on purpose and broad on purpose. So question is what falls under that. And essentially, it's really meant to exclude or prohibit almost any business. There are, again, exceptions. For instance, a legitimate exception is to represent a denied party before courts because they have a right, of course, to legal representation. But often then you need a special license from the authorities to receive your fundings. So these are the main scope. And then if Andy looks at the addressees to have a look who is currently under these sanctions when it comes to Russia.
Yeah, thanks, Jochen. And I mean, there's clearly this sort of very headline grabbing sanctions and listings of Putin, Lavrov, members of the Duma, and a number of others, which, unless our clients are owned or controlled by Putin, which is rarely, if ever the case, going to be, actually, it's also worth noting there are 600 plus others, either on the EU or the UK sanctions regimes, and of course there are US regimes as well. So, and here the key, and just jumping around bullets a little bit, but it's worthwhile just taking, just focusing on that last bullet as well, which is around entities which aren't listed themselves, but which are owned or controlled by listed entities, be it particular organizations, or particular individuals. And this notion of owned or controlled means that you have to look through not just the client themselves, but whether they are owned or controlled by a listed entity. And that notion of ownership or control is somewhat different. In the US, for example, it's around ownership, i.e. does the listed entity have 50% or more of the non-listed entity that's in the EU, in the UK, it's a slightly different notion of ownership or control. So does the listed individual effectively, can they get their way and direct the activities of a particular company in a certain way? If they can, then it's certainly a very high risk, if not a certainty, that they would be treated as a listed entity that you have to have some caution over acting for or with, if you can do that at all. So individuals, entities, let's say there are, through the bullet points, the banks are the big obvious targets at the moment, about 70% of the banking sector. So are the clients there? Does it have general operational difficulties from the commercial point of view? And also other entities. I think in the EU there are 52 entities in a lot of key different sections listed. The UK slightly fewer listed, but actually with the prospect of more coming online. So there is a whole long, frankly, just a very, 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 very long list of individuals or parties that are on this denied party listing, to whom sanctions will apply. And even if they don't, this is that final point again, just to kind of reiterate it, if they are owned or controlled by a listed entity or individual, then they could also be subject to sanctions. So it's always really worthwhile keeping an eye on that. And there are commercial providers that can check the ownership structures and advise or raise flags if one ought to look more closely at that particular structure and whether to act for it. So that's a denied party listing. Going on to the second tranche of Jochen's three areas, the substantive sanctions against Russia. The UK and EU have imposed, and I want to particularly focus on this first bullet point and the headings under that, because this can have quite a far-reaching impact on clients, all of our clients, wherever they're based, as long as they are subject to EU or UK sanctions. So, for example, the export restrictions on dual-use goods. For those that aren't export control geeks, dual-use goods are effectively goods that could be used either for military purposes or non-military purposes. They're listed in a very long list of, into the hundreds of pages, but a very long list of products or goods that are subject to control normally. And normally you can get a license for those and they can be exported. What the UK and the EU have effectively done is to say any of those goods, they will not provide the license and they can't be exported to Russia. And that can be anything from obvious things like tubes for guns, but also more benign things like poppers on a shirt. If they have infrared covering, they are a dual use good. So again, just worth being aware for clients that might be doing exporting of any dual use goods that would have a license in place that could now be severely restricted, if not curtailed entirely for exports to Russia. And then there are provision of goods to certain key sectors, defence and security sector, the oil refining, aviation, some of the high-tech sectors as well. So again, any clients in that we have in those sectors who might be exporting goods to Russia, again, a real red flag and something that needs closer scrutiny. I don't want to go through all of them in terms of time because they're probably less relevant from a commercial point of view, but in particular be aware that more sanctions have been announced against Belarus, often flagged that they're coming. They're still yet to come, but we expect those in the coming days if they're not already set out. And the more noteworthy things like the closure of EU, UK airspace, the prevention of aeroflot landing in the UK, for example, and additional scrutiny on ownership and investment in the UK, which I know our real estate team are already on the case for that. So a flavour of some of those substantive sanctions on Russia.
Maybe to add one point to that. So the important part about this is to understand that if you are in this sector, then there is a risk that your business is affected. If you produce, for instance, children toys, and this is not a listed item here, then there would be no problem with continue to export children toys to Russia, as an example. And so this section, this is sometimes different to the US approach that have a more global approach in terms of imposing close to total embargoes, whereas the EU, where the cooperation is really almost entirely prohibited is with denied parties. But for the rest of the sanctions, if you don't deliver or your contract partner is not a denied party, you can still do a fair amount of legitimate business if you're not in one of those categories. And Andy ran us now through this industry sector specific sanctions. Then one important part that we're still missing is these sanctions that are related to the finance sector or to the money sector more globally. There have already been certain financing restrictions on financing there in the past. They have now been extended quite substantially. The EU says they try to cover about 70% of the Russian banks with their sanctions. And basically, the first part of the sanctions shall prohibit Russian banks from taking up money. So any investment services, loans, transferable securities, anything to generate funds, there are sanctions on that. And if you want to know more about it, we can guide you through them in details. The second part of the sanctions is that for certain Russian individuals, their accounts in the EU will be frozen or blocked, and banks have to report everything that is on them above 100,000 euros. That's not for Russians living in the EU, but for Russians living in Russia with accounts in the EU. You have also seen there is discussions about excluding Russian banks, or at least certain Russian banks, from the SWIFT system. I have seen, we have all seen the heavy discussions, especially over the weekend. I have not yet seen the actual measures, at least on the EU side, but this is something to keep an eye on. This is likely to come as well.
Jochen,
And the EU has also imposed a, sorry, Andy, please.
No, go ahead. Sorry, I was just going to say that on a wider point, your comments, I think, it's worth flagging, at least again, also from the UK side, which is there's lots of announcements being made, and I was advising someone this morning about announcements that be made around, in this case, the access to bank accounts and the limit of 50,000. They have been announced, but the legislation hasn't necessarily come through in the UK yet, as it has in the EU. And similarly, I think at that point of the discussion around SWIFT, we are seeing lots of political announcements, and I think certainly in the UK, to some extent in the EU, often those political announcements come first and the legislation comes some days afterwards, unlike the US, where they often have the executive order signed by the president at the same time he makes the announcement, and it comes effective immediately. So sorry, Jochen, just a sort of slightly wider point that has been picked up a few times over the last few days.
And indeed, this is also intentional from political side, because the purpose of sanctions is to discourage business with the sanctioned entity or sanctioned country. So while there is still a lot of business we can legally do and the clients can legally do, generally, of course, the idea behind sanctions is to encourage that or discourage that, sorry. Next slide. Andy, please.
Yeah.
Perfect. Okay, so then there is also sanctions with regard to Donetsk and Luhansk. As I said, these are pretty much the same as we had for Crimea and Sevastopol. Just the highlights of them, there is generally now in the EU and my understanding in the UK an import ban on goods from those regions. That might be important for clients. For instance, if they have suppliers in Russia, this is an area where a lot of steel industry is located, to make sure whether goods coming from that area or not. There is prohibitions on investment into these regions, and then there are export restrictions to those regions of certain goods and technology and services. So that's a quick run through on the EU side and the UK side. I just texted, if you have any questions, please feel free to put them in the chat box and we'll pick them up.
Yeah, that's a great point. I was going to say, if people do have questions, happy to try and answer them. And if we can't answer them now, then we can always pick them up afterwards and come back to you directly. And I think the interesting point here around the Donetsk and Luhansk sanctions they're quite similar to the Crimea measures. So again, clients that have been managing and navigating doing business in Ukraine and carving out certain elements of Ukrainian territory from the Crimea sanctions will be familiar with it, but I don't think that makes it easy. And how you navigate that with contractual provisions to try to make sure you're limiting any trade in those parts in that part of Ukraine is all practical things we can help with. In reality, of course, at the moment, most trade is not happening simply because of the current invasion that's underway. So that at least means that the risk of doing any business contrary to those sanctions, I think at the moment is obviously going to be very limited. So, but when things start to return to normal, it's worthwhile thinking that through. But I think the world will be a much different place by then, so we'll take stock at that point. And more broadly, we just wanted to touch on the US sanctions, because although we're a European firm, actually a lot of course, drives sanctions and concerns about compliance are the US sanctions and the very heavy penalties that are imposed. They're often, as Jochen alluded to, broader than EU, UK measures, not always, but they can be. And I think it's just worthwhile remembering that in terms of the structure for the latest Russian sanctions, they are in a pretty similar form, either asset freezes or denied parties against individuals, entities, banks, again with some winding down provisions, some licenses to allow business to be tidied up in relation to some of those parties over a short period of time. Again, financial services limitations that we've talked about, increased trade restrictions on exporting controlled goods, and again, all trade in the Luhansk and Donetsk regions of the Ukraine, and Belarus entities have been listed as well, and I think we'll see more Belarus sanctions coming down the track. And again, just to flag, part of the sort of the driving force of US sanctions in considering compliance policies and approaches is the scope of them. And it could be that if you're using US dollars or correspondent banks based in the US, or servers are based in the US, then it might well be that they fall under US jurisdiction, US scope of those sanctions. So again, just worthwhile thinking they're slightly different and slightly more expensive than UK, EU jurisdictional clauses and approach, but always worthwhile being aware. And to make the point that although we're not a UK, we're not a US firm, we can't formally provide the US legal advice. We do work very closely with US partners to provide a kind of comprehensive piece so that clients have that as a sort of one-stop shop for them. So that's a sort of a brief snapshot. I'm conscious of both cantering through, but also perhaps giving a bit more detail than people might be able to absorb in a short webinar. But that's a sort of the snapshot of what the sanctions measures are. Moving on a little bit to how we can help clients, and Jochen, I know you wanted to talk through some of these practical points, so I'll hand over to you.
Thanks, Andy. What we see now, if we speak to clients, is of course they are the first people that really run on full speed are the export control compliance officers, trade officers within the company, and the second person then are the management that basically then have to decide from a strategic standpoint and a firm policy and politics standpoint whether to do certain business or not. So this is what we're dealing with now. And I guess if you happen to receive calls from client, questions from client, do you know about the sanctions? Can you advise on the sanctions? Then this will immediately come from these people and with this background. Maybe we can go one slide back. We have a couple of questions here that we'll not go through them all of them, but this is basically the question we understand from our own communications and from experience, the clients asking themselves currently. So the first thing is, of course, to map out and to measure out who is, how far is our business affected by the sanctions? What are our options going forward? Which business can we do? Which business might we have to stop? This type of questions they ask now, and then in the second question, one, they have basically established the fact, then the next level comes in, and the strategic decision making by management will take place.
Yeah, and it's as Jochen was saying, sorry, I was trying to look at the questions as they're coming in. I'm not very good at multitasking. Yeah, we're having questions from compliance officers, management, general counsels, obviously, and part of that depends upon the nature of the issues. Are we in the middle of an M&A deal, as I work with some of our corporate team on, where this might it might raise the issues of due diligence up the scale again in a way that they hadn't been before. Is it future-proofing some of those concerns, or is it dealing with sort of immediate questions and immediate transactions? At the moment, a lot of this is firefighting and dealing with real sort of immediate issues and immediate concerns of transactions that are underway, of business models that are in place. And we're always very happy to help, of course, and we can deal with those sort of urgent questions quickly. But then, of course, it provides opportunities to really show what we can do and get people's house in order for future purposes on the sanctions, export controls, the compliance piece more generally. So whilst it's always, it's never a fun expense to have, and it's often seen as a sunk cost, I think these sorts of events where actually clients that do have compliance policies in place, I've been well placed to understand actually what is it I need to know, what are the sort of key issues I need to identify, rather than starting from scratch, which is the alternative. So that's a variety of how we can help. And then to go back to this checklist again, the sorts of questions we ask to try to understand: are you caught? How will they impact on you? Are there ways to manage that, to mitigate it? What are the contractual obligations or basis for stopping the provision of services with customers potentially? And it can go both ways. At the moment, we're working with one client who has a sanctions clause, but actually, although they've got a Russian counterparty, that Russian counterparty is not sanctioned. It's a subsidiary of Gazprom. They're not sanctioned, but actually for reputational reasons, they don't really want to carry on with the contract. So how do you manage those different stresses and strains, and what do the contracts say? Often people turn to force majeure clauses, really quite difficult and unreliable, and in some jurisdictions really been no use at all. So you look at the MAC clauses or any particular sanctions clauses that are in place, and obviously understanding the commercial drivers behind each of our clients' interests. So lots we can do, lots to help on, and very much about trying to provide some pragmatic advice to get them over initial hurdles and concerns, and then on a bit more of a steady state in the medium term. So that, by way of overview, is what we can do to try and help. If in doubt, of course.
Maybe for you guys, so if you receive questions from companies, from clients now, I think the first, in order, if you wish to basically have some speaking guidelines or questions you can ask them. So the things you can do immediately is, for instance, to ask them, okay, what are you doing in terms of internal policies? What are your measures taken? Have you checked that whether your products are actually covered by the sanctions? Have you checked whether your customers are subject to sanctions? But also going forward, for instance, those of you who are in corporate, one trigger might be to gain new business is to ask, maybe is it time to review your due diligence and compliance clauses in your standard contract terms again? That could be a door opener, for instance, for you. You could bring us in on that, but it would, for instance, it might give you as corporate team additional work. Another questions might be with regard to litigation. Sorry, there might be situations now where companies want to cancel contracts they went into with Russian clients or Russia-related clients because they feel uncomfortable of engaging in that business, even if allowed, for instance, because they have a fear that they could not be paid. Again, and that might be a point to bring up and discuss with them and see how the sanctions can be used as a defense here in terms of them getting out of a contract. So just some ideas for the background. Employment, it might be an employment issue. Maybe companies do have sanctioned individuals as employees or are not sure. So again, there might be an angle here about work or questions you can ask and discuss with your clients.
Yeah, thanks, Jochen. And I'm conscious that Jochen and I are the sort of two faces, very diverse white male faces on the webinar, but there are colleagues across the system who can help, either in the UK or the EU on sanctions as well. So if you've got any questions, by all means, fire them away to us, and if we can help, we will. If not, we'll find a home for them where people can help and support going forward, because there might well be, it's clearly a flurry at the moment, but the world, I don't think, is going to change dramatically, and we're going to be with these sanctions for some time to come. So it's about trying to get that on a steady state and get the best support for your clients going forward. As we were saying earlier, we've produced an overview of US, UK, EU sanctions. They are changing daily. We will do our best to keep them updated regularly within reason, but of course it's hopefully it's a starting point for a conversation with clients and to show that we're on the case. And as Jochen said, there'll be a deeper dive, I think, on the EU side. We'll try and do a deeper dive on the UK. We'll try and keep across the sort of the breadth of the different measures that are underway, so that there is a bit of a steady state of information that's flowing, and hopefully that's useful. I'm slightly conscious that we've had various attendees arrive after the start, so just to be clear, we'll make sure that these slides, I think the webinar, if you are really keen, is being recorded so you can watch it again, but we'll make sure the slides are available to everyone as well, so that ideas of how we can help, of checklists for clients, you can think through. Just finally, if I can, just think
Andy,
about
one
our own
second, sorry.
lives.
I
Yeah,
see that Tim has posted a question to this, and Catherine and David, we saw your questions. We will discuss them in the context of this last slide. But Tim had posted the questions. Anyone collecting practical updates on deals at the moment, as there's a lot of being discussed, which sits outside the direct impact, but nevertheless stops deals being completed. I think that question on our side, well, if you want to share information with us and have our input on how we see it from a sanctions perspective, we're very happy to give you input. Otherwise, as we're not in the corporate team, we personally would not know unless you tell us. So Tim's question might be for more the corporate lawyers and among you to answer and to give feedback here.
yeah, and
But if
I
you
think
want to create a group or a platform where we share that information for internal discussion, we're happy to be part of that.
yeah, I think that's a great point. And equally, if teams are having a sort of collective head scratch around sanctions and their clients and what they can offer or not offer, what the impacts might be, what lessons we could learn, then again, very happy to join those conversations on a sort of group by group basis, if that's helpful. Because actually a lot of those lessons learned are, as Joachim was saying, probably best within or best unpacked with the relevant teams, but again, happy to help. And if we're learning lessons across those different sectors, we can certainly try and apply that and give some practical advice to build out from there. Joachim, I'm in your hands a little bit of the questions because I'm not quite sure what on my screen ends up showing or not, but if I just pick up on the compliance point generally, and then perhaps you can answer the questions in that context, if that's helpful.
I give you the questions first because I think we can answer them while talking. Catherine asked, are there many of the firm's clients on the denied party lists? And then David asks, can you comment on the firm's position on acting for individuals or businesses associated with the Russian government, whether sanctioned or not?
On the last one, no, speak to Michael Chiswick. I think that's probably the easiest thing to say. I mean, we do represent sanctioned individuals because I think that, on a serious point, people are entitled to have the right to have their points made and representations, and we've got people delisted who should never have been on the list. Particularly Vivian Davies has been doing a lot of amazing work on that front from DR side. So, there is a need to represent people on occasions, but I recognise there's a sort of a corporate question around that, and I think that's well above my pay grade. So I will hand that very difficult question to Michael. And on the clients on denied party list, I mean, the AML process is always, the team in Belfast and across the network are working hard to make sure that we don't advise people who are otherwise sanctioned, or where there's a risk of that. Or at least we do that on an informed basis in a way that gets a proper license for the legal advice, depending upon the nature of the advice that's being provided. And in some cases, there are sanctioned individuals or entities where there are licenses in place specifically to allow them to get legal advice or support. So I think that is very much, I think this really feeds into the wider compliance point, which is we just need to be alive to these issues, and if in doubt, frankly, speak to local risk compliance officers, and there's an email address at the bottom there to perhaps copy to, so that there is a collective Fieldfisher understanding of what the concerns are that are out there, and really just to sort of think through and be informed and knowledgeable about the potential risks that are there. So obviously, is your client a sanctioned entity? Flowing from there, are there licenses in place? What's the sort of advice that's to be required? For the most part, I think we are advising clients who are concerned about engaging with or providing economic resources or benefit to sanctioned entities. So it's normally on the other side, but but of course we need to think through all possibilities. Similarly, if we're instructed by a law firm as the underlying client sanctions, again, all part of the KYC really, but just given the additional sanctions and denied party lists that are expanding day by day, always worthwhile being alive to these things. Similarly, owned by an SPV or other non-obvious entity from a denied party list, and providing support to sanctioned entity, e.g. on the other side of a transaction. And then carry on.
You probably have seen the email Michael sent yesterday. He sent circulated an email about the Russian sanctions and the firm approaches to it. So that is our best advice from maybe a common sense feeling. If you are offered business, of course, the first thing is to check, of course, internally, but business that, for instance, a sanctioned person asking you to help them with a contract to for a weapon supply, that should probably be an absolute no-go. But a sanctioned person asking for help to get delisted, again, would be another thing. That should normally be fine. From a legal side, now there is of course also the firm policy side, and then there's a lot of gray zone in between. I think on the other question, there is a review on the number of people that are on a sanction list within the firm, and that's within the firm, clients of the firm that are subject to sanctions, and this is done by the risk and compliance team, to my understanding. And yeah, please check in with them. I guess if somebody is client partner for one of those, I would assume they would inform you then respectively.
Yeah. And just a practical point about making sure all else being equal and you can carry on revising, can you be paid? How the bank, what are the payment methods or banks are being used? Particularly thinking about the listed entities and listed banks, but also, of course, in particular, the sort of potential access to SWIFT or otherwise. So just have a weather eye on that from a practical point of view. And I think a lot of this is really, we've obviously focused on the law. There is clearly a lot of consideration with clients around the reputational management alongside the legal side. So I'm conscious that we have focused on law, but we are all advising clients in the real world context, and they are thinking through, and we will provide our advice in that context and in a practical way to help them navigate what they need. Jochen, are there any other questions? Otherwise, I'm conscious of taking up people's time.
I don't see any other questions. If you have any other questions, now is your chance.
Otherwise, we'll make sure that these slides, I think the webinar will be posted somewhere on the intranet with access to that. The slides will be available as well. And if you've got any questions, of course, by all means, come to me or to Jochen in the first instance, or if it's around your own advice and compliance, then of course your local compliance officers and the risk and compliance email address at the bottom of that slide. I think with that, just leaves me to say thank you, in particular to Jochen and to the team who helped pull some of the slides together, and to colleagues who are being very patient, asking advice, to whom we're getting back to as quickly as possible. Anything further from you, Jochen? Otherwise, I'll say thank you very much and goodbye.
Thank you from my side as well.
Thank you.